An update in the disturbing case of a Michigan mother accused of abandoning her 3 children, leaving them alone in squalor. Kelli Bryant is now out of jail, released on bond after spending months behind bars. Her release comes just weeks after her jailhouse phone privileges were revoked after being accused of violating a court order by reaching out to the very children she's forbidden to contact. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime. Kelli Bryant has bonded out of jail after officials say she left her 3 children alone for years inside of a dirty, feces-filled home in Pontiac, Michigan. The sheriff expressing outrage when it happened.
You wouldn't do this to an animal, let alone your child.
Bryant faces several charges, including child abuse, for allegedly leaving her 3 children, ages 15, 13, and 12, alone in this house of horrors. The home was so filthy, officers reportedly had to wear hazmat suits and masks. Photos show an overflowing toilet and a bathtub filled with feces. The rooms, according to authorities, were unlivable, with garbage piling up to 4 feet high. The children had been reportedly left alone since at least 2021. Oakland County prosecutor talking about the severity of the situation when Bryant was first charged.
The children were afraid to come out of their hiding places and to speak with the police. Police had to repeatedly advise the children that they were there to help and they were safe. The children's bodies and clothing were covered in feces, and the girls had difficulty physically walking outside of the residence.
The mother is now free after spending over 100 days behind bars. Her bond was drastically reduced from $250 million to $50,000. Per the conditions of her bond, Bryant is not supposed to have any contact with the children, including physical contact or anything digital. Back in March, Bryant's jailhouse communication privileges were revoked after prosecutors say she violated a court order prohibiting her from having contact with her children or their caregiver. Bryant allegedly called her children's caregiver 10 times between March 8th through the 12th and also had other jail inmates call the caregiver on her behalf. Bryant's attorney said she was unaware that she couldn't call the children's caregiver. Bryant was also hit with additional charges for welfare fraud. Prosecutors say she continued to collect public assistance for the children after abandoning them. She allegedly collected nearly $30,000 in payments between 2022 and 2025. And here to break down this story with me is professor of law at Temple University and a former child abuse prosecutor, Marian Bracha. Marian, thank you so much for coming on today.
Of course, Kennedy, good to see you.
So let's just jump right in. Kelli Bryant recently bonded out of jail. What's your reaction to that? And why do you think the judge drastically reduced her bond from millions of dollars to what it was now?
Right. Well, I mean, there's only one charge that in most states recognizes the constitutional right to be held without bail, and that's a homicide charge. And so in this particular case, thankfully, there is no homicide at issue. There's no one who died, thankfully. So I would think that in the interim, between the original bail being set at $250,000 to the reduction, that the defendant's attorneys were able to show an interest in defending her case, that the defendant was not a flight risk, that she would be present, because that really is the purpose of bail, is to assure a defendant's presence at the trial. And so absent any indication that she would flee or that she would abscond or be a flight risk, the bail in many instances would be lowered to something that she could post.
This is a Law and Crime legal alert. If you received Depo-Provera birth control shots and were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. Morgan & Morgan is investigating claims that patients weren't properly warned about this risk. It's free to check, takes just a few minutes, and you don't pay unless they win. So scan the QR code on your screen, click the link below, or go to forthepeople.com/LCDepo to see if you qualify. But this is a jaw-dropping reduction, I would say. We went from $250 million to $50,000. Is that typical in a case like this, or does it raise questions about how bail decisions are made? Or was $250 million just outrageous to begin with?
Well, I mean, being held on $250 million bail is tantamount to being held without bail, right? So, because there are very few people, if any, who would be able to post a 10% bond of $250 million. So, there was arguably an excessive amount of bail placed, and I understand certainly the severity of the charges and the argument that this is someone who perhaps should have been held without bail. But again, the purpose of bail, and this is a nationwide debate that's been going on for about a decade now about the purpose of bail. So there are some advocates to oppose the bail system that would say that setting bail so exorbitantly high makes it impossible for certain defendants, in particular indigent defendants or poor defendants, to be able to post bail. And so there is already a punitive measure in place. The argument is that we're essentially punishing people for being poor and not being able to post their bail. So I can't speak to what is an ordinary reduction. That will vary by jurisdiction, from county to county, from state to state. So I don't know what the average amount of bail in a case like this in this particular county would be. But I think a bail reduction, once there's been a showing that a defendant is not a flight risk and is will be a reliable presence at trial, is not uncommon.
Do you think her release poses any risk to the children? Because we know that, according to prosecutors, Bryant allegedly contacted her children while she was in jail after being told not to. Either, you know, I think she was trying to contact them through their caregiver at the time. So just how seriously does the court take that?
Very seriously, very seriously. So whenever there is bail, ordinarily in cases where there is a complaining witness, where there is a named victim on the case, a condition of release would be a stay away order or protection order, meaning that the defendant is to have no contact with the named victim or anybody on their behalf. And so if this defendant violated that already from custody in attempting to make contact with her children or with their caregivers, that would indicate to the judge that she might thumb her nose at future court orders or future stay-away orders. So being out of custody poses an even greater risk, because then she has freedom of movement. She might go over to their house or wherever they're staying and try to have contact with them, which is in arguably even more invasive and a greater level of contact than a phone call. So I do always think that there is a risk to the complainants, especially if the stay-away orders are not abided by. But again, the argument for bail in a case like this is that if she can guarantee her presence, that she is allowed to participate in the preparation of her defense while not in custody.
Right. And it could also be considered witness tampering or obstruction of justice, right? Like if she gets in contact with the kids.
Right. And it depends on the nature of the contact. If she's trying to tell the kids to change their story, or trying to influence their testimony in some way, or trying to coach them to report certain things or not report certain things to authorities, that could certainly be considered witness tampering. If this, however, is a remorseful mother and she's trying to reach out to say, I love you, I'm not sure that would qualify under witness tampering. So, of course, like most other actions under criminal law, intentionality will be key to determine if there's an appropriate charge to attach to that attempted contact.
Right. Well, let's talk about the conditions inside of that home. Officers said that they had to wear hazmat suits. How does that level of neglect impact this case legally?
Well, again, it goes to show an intent, right? And it goes to show that that this isn't just something that she didn't notice. This isn't something that was a situation that was getting worse or exacerbating little by little over time. If this was a home, a setting that was so infested and so filthy and in such dire conditions that investigators required hazmat suits, the argument from the prosecution would be it would be pretty hard to miss that, and hard to claim that you didn't know that your children were exposed to such squalor and such poor conditions. So that is, I think, very important, especially to the gradation, because she's been charged with a first-degree child abuse or neglect of child charge, and so the just how bad the conditions were inside this property will go to substantiate the gradation of the child abuse and neglect charge.
Does the fact that the children were essentially hiding from police tell us anything about just their trauma or coercion that could come up in court?
I think it could. It certainly could, and it also it goes to show that these children, I would argue, knew that there was something wrong. They knew that they should be under the radar, that they should stay off the grid, that they shouldn't draw attention to themselves or the fact that they were without a caregiver. And that just goes to show that if children know or should have known that there was something amiss in this scenario, that their parent, their adult caregiver, their guardian should also have known that these children were being exposed to risk and being neglected. So I think that the children's behavior speaks volumes about the severity of the neglect in this case.
Do you think that the children will testify in this case? And if so, what kind of protections can be put in place to avoid re-traumatizing them?
Well, I think it is likely that the children will have to testify. At least one of the children would have to testify. I think what needs to be established is the level of absence and the level of neglect by the defendant in this case. And so I could foresee without the children's testimony, a defense argument might be that the defendant hadn't actually left them for this long period of time, and that she was also living in these poor conditions. And again, there might be a defense to that. That perhaps she was ill or incapacitated or working to support herself and her children. That I can anticipate a defense that she just didn't have the means or the wherewithal or the ability to care for her physical environment. And so without the children's testimony to say mom hadn't been home in X period of time, it would be really hard to establish the level of neglect. Now, of course, you can prove any element of any crime charged with circumstantial evidence. And so the mere fact that when investigators found the children, these were the conditions that they found the children in and the conditions of the living environment that they found, including all of the trash and the human waste and just the terrible conditions that they were surviving in. And so even without their mother's absence or their mother's physical neglect, the argument could be even with an adult living on these premises, living with them, this was no condition for the survivability of any human being, certainly not a child who's still growing and developing. So I could also envision a world where their testimony is not entirely needed, but to make out, again, the gradation on the first degree charges of neglect, I would anticipate that at least one of the children would be needed to testify about how long it had been since their mother had been present and cared for them.
Right. And I would also anticipate that maybe police would use the kids' text messages. We see, through reports that the mother was dropping off food about once a week and communicating, I think, with the oldest, who was 15 years old. So maybe they could use that as well to show, hey, if your defense is that you were home or that you did live with the kids, then why, do these conversations seem to prove otherwise? What do you think about that?
Absolutely. And so they would certainly, the prosecutors, if they sought to use these text messages, would have to find a way to authenticate them, which means that they would have to establish that the communication was occurring between the defendant and one of her children. They would have to link back the text messages to the parties involved in having these communications, because standing on their own in a vacuum, we can't know just reading them who was sending them and who was receiving them. And so there would need to be an evidentiary strategy in place to what we call authenticate these messages and establish that they are what they purport to be, which is a message from the defendant, the mother, to the complainants or the victims, in this case, the children. But that is an evidentiary question that the prosecutors would have to prepare for pre-trial.
Right. And speaking of evidence, just those gross photos. I mean, those children, those poor children, they were just living in squalor, in waste, just disgusting. You see all the feces and the food. Police saying that there was garbage stacked up to 4 feet high in some areas. The sheriff even called it something you wouldn't even do to an animal. Do emotional public reactions like that ever impact the legal outcomes? Because I'm just thinking about the jury. How will a juror react to seeing something like this and to hearing just the gross details?
Absolutely, Kennedy. And testimony like this is arguably inflammatory. It might be accurate. It might be, well, this is purely factual. This was the situation that police found. These were the conditions that these children were living in. The jury has a right to hear the nitty gritty and the full scale of ugliness and horror that these children were living in. And the prosecutor's response would be, I can't sanitize everything. I can't make the evidence in this case cleaner or more palatable or less stomach turning just for purposes of making it less emotional, because the reality is that it was actually this horrifying and this disgusting. I think the defense argument would be, again, under the rules of evidence, that if there is evidence that would be unduly prejudicial to the defendant, meaning that its prejudicial effect would substantially outweigh its probative value, which means that the weight that it carries and the value that it brings to the case, that it would just serve to prejudice the defendant. So there is, again, going to be a little bit of an evidence battle between the defense and the prosecution as to the extent of the description and the extent of the visual aids that the jury would be entitled to see what the conditions were that the children were living in.
And let's talk about the welfare fraud charges. Ms. Bryant allegedly collected close to $30,000 in benefits after allegedly leaving the kids. How significant are those in comparison to the abuse charges that she's also facing? Could they lead to federal involvement potentially?
They potentially could, right? Because if these are federal funds that she's receiving and that she was receiving fraudulently or under false pretenses, that she was actually with the children, caring for them, providing for them, that could be the basis of a federal charge. My initial reaction to the addition of the welfare fraud case, the welfare fraud charges, was that it kind of adds insult to injury, so to speak, that it's bad enough that someone would abandon their children and let them live in such horrible conditions, and then on top of that, capitalize on that criminal behavior and be making a profit from it and still be collecting aid from the government for not really providing for or caring for your children, which was what the intention of the funds were to begin with. So to me, if those charges were joined to the original complaint, I think that would, again, be something that the defense could potentially argue against and would argue to sever those charges as potentially prejudicial against the defendant. And that would be up to the trial judge to determine whether or not the jury hears both of those charges together or evidence of both of those charges together, or whether they are separated for purposes of trying the case.
Yeah, I was just about to ask if we expect the welfare fraud charges to be tried separately from the abuse charges. But it seems like they kind of go hand in hand, but I can understand from the defense perspective, maybe that will, make their client look worse. I don't really know. But does a judge usually separate charges like this?
I can't speak to generalities. I think it really is on a case-by-case basis that that judges make a determination as to the severance of charges. But I think you hit the nail on the head when you said they kind of go hand in hand. So the welfare fraud, according to the prosecution, would be all part of the story of the case. It wasn't just that she was, heartless or inconsiderate or not a good housekeeper. And I'm certainly not trying to be flippant about the facts of this case. But in addition to that neglect, the prosecution argument is going to be that there was an intent behind it. And the intent was to collect aid that was intended for the children and ostensibly use it for the defendant's own benefit. And so, again, I think you hit the prosecution theory on the head when we say those charges and those actions go hand in hand if we're looking at a case, at this case, in a holistic way.
Let's say Ms. Bryant is convicted on all charges. What kind of sentence could she realistically be facing?
If she received the statutory maximum on each of the charges, she could be looking at upwards of 60 to 80 years in custody. So that would be tantamount to a life sentence for her at this point.
Wow. Wow. Well, as this case moves to trial, what are the key things you'll be watching for that could shift the outcome?
I think importantly is whether or not the children are called to testify. I think importantly is also what proof, what independent proof there is aside from the children's testimony. What little contact the defendant actually had with the children in the time that she was allegedly caring for them and living with them. I think that is probably a turning point fact in this case as to whether or not the full neglect charge can be established and can be made out. And again, without the children's testimony, without knowing what other witnesses can attest to the fact that can attest to how long and for what period of time the defendant was absent from this property and from the lives of her children and for caring for her children, aside from these food drop-offs at intervals, I think that is probably the most important fact of the case.
Absolutely. Well, this is a case that we will be following closely. Marion, thank you so much for coming on today.
Thanks for having me, Kennedi. Have a great day.
Kelli Bryant is scheduled to be back in court on June 18th. For Law and Crime, I'm Kennedi Walker.